afternoon, everybody. Welcome to today's seminar, Approach to Service Out, a State of Confusion. My name is Alan Gibb from the Faculty of Law at CUHK. Now, today's seminar is going to focus on a very important issue in commercial litigation, the Order 11 gateways that allow the Hong Kong courts to exercise long-arm jurisdiction, particularly in the context of the tort gateway, concerning which we've had three very important recent decisions, two by the English Supreme Court and one by the Hong Kong Court of Final Appeal. So today's session, the aim behind it is really to critically analyze these decisions and really try to assist us in understanding the relationship between the actual wording of the Order 11 gateways and this concept that Lord Collins has created, the spirit of the gateways, and then the principle of forum non-convenience. So what's the relationship between these three connected entities? So I'm delighted today to welcome the co-authors of an article on this particular topic, published recently in the Lloyd's Maritime and Commercial Law Quarterly. Kelvin Say, who's graduated from CUHK JD program. He was first in his year, so welcome back to your alma mater, Kelvin, and then obtained a BCL at Oxford University and is now a pupil barrister in Hong Kong. And Alex Chan, who graduated from Hong Kong University with the first class LLB, and then obtained a distinction in the BCL program at Oxford University, and he's going to soon start pupillage as at Temple Chambers in Hong Kong. So we have the normal system whereby we'll allow it at the end some time for questions. If you have any questions, please write them into the chat function on the Zoom screen. And without more ado, I'll hand you over now to our speakers. Okay, Kelvin, you can go ahead now.
Hello, Professor Gibb. Am I audible?
Yes, I can hear you, yes.
Thank you. Thank you, Professor Gibb, for the introduction. And I'm pleased to be joined by my colleague, Ms. Alex Chan, in giving this seminar. So before we start, I would like to have a word over the title of the seminar, which is Approach to Service Out, a State of Confusion. Alex and I have actually thought about the wording of this title, because whilst it may seem eye-catching for obvious reasons, it may not be a fair summary of the law on service out. But apparently, in light of the recent Hong Kong Court of Final Appeal case, Fong and Centric, and given the subsequent development of the decisions in the Court of Appeal, we think that this may be a fair statement, and there's still a substance therein. So without further ado, I shall first address the substantive part of this seminar. This seminar will be divided into two parts. The first will be the English and Hong Kong rules on service out, and the second will be the Hong Kong Court of Final Appeal case, Fong and Centric. So on the first part, addressing the English position, the starting point will be the Civil Procedure Rule, Rule 6.36 and 6.37. So 3.6 provides that in any proceedings to which Rule 6.32 or 6.33 does not apply, the claimant may serve a claim form out of the jurisdiction with permission of the court if any of the grounds set out in paragraph 3.1 of the Practice Direction 6B apply. It is noted that the paragraph 3.1 of the Practice Direction 6B actually contains the gateway, the so-called jurisdictional gateways, and the 6.37 basically addresses the requirements on the affidavit to be filed in an application for service out. As to paragraph 1, it requires that we have to state grounds in paragraph 3.1 of the Practice Direction 6B. And we also have to state that the claimant believes that the claim has a reasonable prospect of success. And over to subparagraph 3, it states that the court will not give permission unless satisfied that England and Wales is the proper place in which to bring the claim. So essentially, we say that the conventional requirements for service out are reflected or manifested in these procedural rules. And moving on to Practice Direction 6B 3.1, these are actually the real terms of the gateways. And what we have stated here are the conventional gateways that the parties will rely on. So, for instance, the first one is a person domiciled within the jurisdiction, and the second concerns agency and any establishment, and the second one, actually this subparagraph 2, concerns injunctions, ordering the defendant to do or refrain from doing an act within the jurisdiction. I shall foreshadow at the moment that this course will be addressed later on. So next slides. Again, the third one, it basically concerns the necessary and proper party limb, as many of you will know. And 4 and 4A are rather more peculiar, and I will not address this in detail. Oh, the fifth one, it's interim remedy under Section 25, Sub-Rule 1 of the Civil Jurisdiction Judgments Act 1982. Again, I will address this further in detail. So the next slides will be claim in relation to contracts. This is the conventional gateway contracts, practice 6B, limb 6, and 7 concerns breach of contract, and the 8th again concerns contracts where if the contract was found to exist, it will comply with the conditions set in paragraph 6. So the next slides concerns the claim in tort, which in a sense are material similar to Order Rule 11, Rule 1 under the Rules of High Court in Hong Kong. It concerns a claim made in tort where damage was sustained or will be sustained within the jurisdiction. Damage which has been or will be sustained results from an act committed or likely to be committed within the jurisdiction, or the claim is governed by the law of England and Wales. This limb, Rule 25, actually concerns a rather interesting point, because prior to, I think, October the 1st, 2022, there was no such rule in the UK. And this rule actually provides for service out in circumstances where the parties would like to apply for interim measures or interim relief against a non-party. That includes not-for-profit relief and bankers' trust. As I said, there is no Hong Kong equivalent. There actually remains the position that there is no Hong Kong equivalent rules to Rule 25. As stated in the White Book, it states that an application for not-for-profit relief against the party outside the jurisdiction cannot be served under any gateway in Order 11. And Gateway C, which is the necessary and proper party limb, will not be available in a standalone application. And this authority in the UK addresses basically the position of the UK prior to the introduction of Rule 25, which is the new rule on not-for-profit and bankers' trust. And in that case, the court held that the paragraph 3.15 of the Practice Direction 6B, which addresses the interim remedy provision, which is over back to this slide, it's not applicable to that case, because a not-for-profit relief is not a remedy, it's not an interim remedy, it's between the parties. It's rather a final remedy against the respondent, which was a bank in that case. So this again explains the reasoning why the injunction gateway, which is stipulated in Practice Direction 6B, paragraph number 2, is not applicable because the injunction sought in that case does not concern any order to do anything within the jurisdiction. Rather, the relief sought is to order the respondent bank to provide certain information outside the jurisdiction, and therefore the injunction gateway was not applicable. And again, the necessary and proper party limb is also not applicable because in the context of a non-pharmaceutical banker's trust, there is no anchor defendant. Rather, the parties involved is the claimant and the bank itself. So one cannot really rely on any anchor defendant in the substantive claim to serve the application for a non-pharmaceutical banker's trust on a third-party bank. Now we have addressed the English position, especially on the procedural rule side. Now we move on to the principles. So insofar as the UK is concerned, or at least the England and Wales is concerned, the principles on server results are rather well established, if I may say, prior to the CFP case on fine authentic. So the first case we will look at is the C-Consile and Bank Acassi, which was delivered by Lord Gough. So essentially, there are 3 requirements on server over jurisdiction. The first is a good arguable case that the case falls within one of the gateways under the practice direction. The second is a serious issue to be tried, and in this case, Lord Gough held that this limb serious issue to be tried is to enable the court to exercise discretion to grant leave, and I stress that because that will have a bearing on some of the reasonings of Lord Collins later on. And the third limb, it's the discretionary test, which I quote, with particular reference to the issue of foreign convenience. So far so good. These are the 3 requirements for an application to serve us out. And again, the case of C-Consile was in 1994. And the position remains in 2012, where in the case of KN Investment, where Lord Collins himself actually repeated and summarized the area of the law, he said, of course, the claimant must satisfy the court that in relation to the foreign defendant, there is a serious issue to be tried on the merits, i.e. a substantial question of fact or law, or both. And second, the claimant must satisfy the court that there is a good arguable case that the claim falls within one or more classes of case in which permission to serve out may be given. And in this context, good arguable case connotes that one side has much but better arguments than the other. And the third is where the claimant must satisfy the court that in all the circumstances, it is clear and distinctly the appropriate forum for the trial of dispute. And this, as is the conventional understanding, connotes the principles enunciated in the Speedy Other case. One question that may pop up at this juncture is whether the word proper place is same as the foreign convenience principles. Because if we recall in this to the earlier slides, as I said, the Rule Points 37 subparagraph 3 states that the court will not give permission unless satisfied that England and Wales is the proper place in which to bring the claim. So is this word proper place equal to foreign convenience? And apparently prior to the CFA case on foreign and authentic, the UK position was that the proper place is the same as foreign convenience, as stated by Lord Briggs in the case of Vendetta in the UK Supreme Court, where he stated that it has previously been labeled foreign convenience and an appropriate forum. And the task of the court is to identify the forum in which the case can be suitably tried for the interests of all the parties and for the ends of justice. And again, that refers to the Speedy Other principle. And this position is also repeated in the Brownlee No. 2 by Lord Legate, although it was a dissenting judgment. And that is the UK position. And now I shall hand it over to Alex to address us on the Hong Kong position. Thank you, Alex.
Hello, Alex. We can't hear you.
Sorry. So I'll speak a few words on the Hong Kong position on the service out, which is contained in Order 11 of the Rules of High Court. But before I take a look at the wordings of Order 11, there's one point which I want to make, and which is that service out is actually quite a big topic, in the sense that it is not only writs which can be served out of jurisdiction. There may well be other documents, such as summonses or even court orders, which may be served out of jurisdiction. And that in this talk, we're only concerned with the question of serving writs out of jurisdiction. But there are actually interesting questions arising from the service of other documents out of jurisdiction. And just to take a few examples, if, for example, I already served a claim and a statement of claim out of jurisdiction, and say if I later amended the writ and the statement of claim, do I actually need to obtain leave to serve out afresh? Common sense would suggest that if the amendment is just of very trivial or minor nature, for example, just correcting a typo in the statement of claim, then it might not be necessary to obtain further leave. But also, if one looks at the matter the other way around, it certainly cannot make sense if one can first draft claim for which leave to serve out is permissible, and then add 10 additional claims to that original claim without obtaining further leave. So these are all sorts of interesting questions in relation to the stage of proceedings after the initial writ has been served out. So if we look at the Hong Kong rules in great detail, the first point to make is that the principles adopted by Lord Kelvin C. Consar is actually adopted in our Hong Kong Court of Appeal in the case of Dynasty Line and Sucam Sia. So there, Miss Justice Zhang J.A. said at paragraph 29 that in order to obtain leave under Order 11 Rule 1, the plaintiff must satisfy the court that first, there's a good arguable case, that the case falls within one of the gateways, and secondly, the discretion should be exercised in favor of the applicant in the sense that first, there is a serious issue to be tried on the merits, and secondly, Hong Kong is the appropriate forum or the forum convenience for the trial of the action. So we may make several observations from this principle. The first is that it is so well established that all people believe that this is the only framework in relation to service out in Hong Kong, so much so that some people actually have overlooked the exact wordings of Order 11, which I'll turn to in a moment. Second point is that there is this quite similar threshold of good arguable case and that of serious issue to be tried. So, but it's important to distinguish what these two thresholds each relates to respectively. The good arguable case standard refers to the fact that the case has to come within a certain gateway of Order 11, whereas the serious issue to be tried threshold is on the merits of the case. So there are two distinct requirements here. But then if we look at the exact wordings of Order 11, so Order 11 Rule 1, one will see that the order itself does not actually provide for such a framework. So the very structured framework that first good arguable case in relation to gateway, serious issue to be tried, and forum convenience is not actually reflected in the exact wordings of Order 11. So if we look at Order 11 Rule 1, it only says that provided writs not to reach paragraph 2 apply, service out of jurisdiction is permissible with the leave of the court in the following gateways. We're all familiar with the gateway, for example, Gateway A, where the defendant is resident within the jurisdiction. Gateway B, Injunction Gateway, where defendant is ordered to do or refrain from doing something within the jurisdiction. Necessary and proper party, and then Gateway D relates to contract, forcing, rescinding, dissolving, or concerning breaches of contract made within jurisdiction governed by Hong Kong law, etc. So Gateway E, breaches committed within the jurisdiction. Gateway F, action founded on tort, damage suffered or resulted from acts committed within the jurisdiction. So we're all familiar with these gateway, but the important point to note is that Order 11 Rule 1 itself only says that service out of the jurisdiction is permissible with the leave of the court if one of the gateway is satisfied. So the main rule in relation to the test in which the court considers in relation to granting a service out application is actually Order 11 Rule 4. Order 11 actually does not contain Rules 2 and 3. It contains only Rule 4 after Rule 1. And so it says that no such leave shall be granted unless shall be made sufficiently to the court that this case is a proper one for service out of the jurisdiction. So the test for the court is actually only the guidance, and the only guidance to be found in Order 11 itself is that the court has to be satisfied that the case is a proper one for service out of the jurisdiction. So the framework as outlined by the Court of Appeal in the Dynasty case actually is not provided for directly in Order 11 itself. It's a matter for the court to develop. So one may say that the framework contained there might not be as stable as it seems. It may develop over the period of time as a matter of common law, for example. The court may sometimes say that, oh, actually all these sorts of discretionary exercise can be merged into one overall consideration of discretion, or the court may even say that even if all the three conditions here are satisfied, the court may still dismiss an application for service out if, in the court's view, it's not a proper application in the event, because Order 11 Rule 4 says that leave is granted only if the court thinks the case is a proper one for service out. So the point is that although the framework for service out is quite well established, one still has to look at the actual wordings of Order 11 to see what it is actually about. Yes, so basically concludes basically some brief words on the Hong Kong position. So we'll move on to the Fong case here, and I'll hand over back to Kelvin. Thank you.
Thank you, Alex. So now it's part two, where we will explain a bit further the reasoning of Lord Collins and the decision of Fong, Chek Kwan, and Ascentic Limited. Obviously, it is quite a heavy decision because Lord Collins addressed quite a number of issues in relation to service out. But let's do a recap. Alex and I just now went through the Hong Kong and English rules on service out. And although the principles which the court will consider in an application may not be exactly reflected in the procedural rules itself, but let us assume for the moment that the well-established requirements for service out is first, a serious issue to be tried. Second, there's a good arguable case that the case falls within one or more of the gateways under the relevant procedural rules. And the third, it's the discretionary test, which is the wrong convenience principles. So moving now on to the case of Fong and Ascentic, the facts are fairly straightforward. Essentially, the plaintiff, a worker, was assigned to do work in mainland China. And whilst at work, he was injured and he suffered personal injuries. And when he returned to Hong Kong, he received medical treatment. And he later commenced proceedings against both his first defendant and second defendant. In relation to his first defendant, he was able to serve within jurisdiction. But for the second defendant, the plaintiff will have to serve it out of the jurisdiction because the second plaintiff was a US company. And in first instance, before the first instance court, the plaintiff was able to serve a concurrent writ out of the jurisdiction pursuant to Order 11 Rule 11F, which was the tort gateway. And later on, default judgment was entered against the second defendant, and the plaintiff's claim against the first defendant was settled. There was an interesting part where the Employees Compensation Assistance Fund Board decided to intervene and take over the second defendant's defense because of the potential implications for the board. And therefore, the board applied to set aside the order granting leave to the plaintiff to serve the writ out of the jurisdiction on the second defendant. And by the time of the hearing of the application, the defendant the plaintiff's position was that the cause of action in negligence had been completed in the mainland, and that he only experienced indirect damage in Hong Kong. So he admitted, he recognized that he only suffered direct damage in the mainland and indirect damage in Hong Kong. And the judge rejected the board's application to set aside leave on several grounds, and one of which is that the word damage, according to its natural and ordinary meaning, basically embraced consequential or indirect damage felt within Hong Kong, provided that it was of some significance. It did not need to be any direct damage or to be put any restrictions on such wording. And the Court of Appeal also upheld the judge on these points. So the board then appealed to the Court of Final Appeal on basically two questions of law. The first is whether Section 33D of the Employees Compensation Assistance Ordinance was applicable, and second, whether damage in Gateway F, which is the tort gateway, was limited to damage directly caused by the alleged tortious act, or whether it extended to indirect or consequential damage sustained within the jurisdiction. As to the first question, that was addressed by Ribeiro PJ, whereas the second question was, for apparent reasons, addressed by Lord Collins. So moving on to Lord Collins's analysis on the gateways. Before he went on to substantively address the issues, he explained the developments of the service out under the UK and the Hong Kong rules. And he also examined the reasoning of the majority and minority reasoning in Brownlee 1 and Brownlee 2. And in doing so, he took several steps. First, he explained the purpose of the gateways. And this line, he said, the purpose of the gateway is to set out a list of the situation in which the legislator considers that there may be a sufficient link with Hong Kong to justify a defendant in another country or law district being sued in Hong Kong. And in some cases, the link may be tenuous. His lordship laid out 4 examples. First, is Gateway C, where his lordship thought that the necessary or proper party limb under the procedural rules are not founded on the necessary territorial connection between the claim, the subject matter of the action, and the court's jurisdiction. And the second example his lordship gave is Gateway A, which is the limb on domicile. As many of you may know, domicile is a rather complex concept, but it's also a rather technical concept. So a person domiciled in Hong Kong may not necessarily have a real and substantial connection in Hong Kong. He may be domiciled somewhere else, far off the Cayman Islands, but in practice, he resides in Hong Kong. So that gateway, as his lordship considered, is also sufficient to constitute a link between the claim and the jurisdiction of the court. And the third example is Gateway D, where a contract was made in Hong Kong, but again, the parties and the transaction may have nothing to do with Hong Kong. And that actually goes back to the limb on contract, and it is rather a technical and more complex limb where parties applying for service out would have to satisfy a number of requirements, including where the contract is performed, whether the contract must be in Hong Kong, etc. The fourth example is Gateway M, where the claim is brought to enforce any foreign judgments or arbitral award, and that jurisdiction exercisable over foreigners even where the judgment debtor or award debtor has no assets within jurisdiction. And as is commonplace now, although Hong Kong is rather a famous place for a seat of arbitration, but the parties and the subject matter of the transaction may not actually be substantially or really connected to Hong Kong, but rather still under the procedural rules, this lien will suffice to fulfill the requirements that of a connection between the claim and Hong Kong's jurisdiction. Lord Collins then turned to the majority judgments in the Brownlee cases, and essentially his lordship adopted the majority reasoning in deciding that the term damage is not confined to direct damage, but rather includes both indirect or consequential damage, including any financial or physical damage suffered in Hong Kong, so long as the damage in question is of substance or of significance. One thing to note here is that Lord Collins' analysis on the purpose of the gateway actually provided a sort of foundation for his subsequent conclusion, and also the analysis of the issues that became quite controversial. And I shall again foreshadow at the moment, which I think Alex will address later on the issue of letter and spirit rule. And the next slides will be the letter and spirit rule, which I think would be appropriate to hand it over to Alex to address in greater detail.
Yes, thank you, Kelvin, again. So we then come to the important part of judgment in the form case, which Lord Collins dealt with the letter and spirit rule. So in this paragraph, he revived principle, the old principle, long forgotten principle. It's a principle which has been forgotten for 20, 30 years by the legal profession in all sorts of service out cases, in almost all service out cases, with a few distinct exceptions. So in this paragraph, Lord Collins said that it is well established that in deciding whether a case falls within one of the heads of jurisdiction, the court must consider the substance of the matter and not only consider form, or not only consider whether the case technically falls within the gateway, but he said that the case must be clearly within both the letter of the rule and the spirit of the head. So this is what we call the letter and spirit rule. So in his lordship's view, in order to fall within the gateway, it must fall within the spirit of the gateway, as opposed to merely falling within the letter of the gateway. So immediately following, his lordship said that the authorities show, contrary to recent dictum by the English Court of Appeal, which I'll return in a moment, this principle applies to the question whether the claim falls within the spirit of the gateway and not simply to the exercise of discretion. One point which we may note here is that it's not entirely clear what Lord Collins was talking about, because this principle is exactly the principle that a case has to fall within the spirit of the gateway. So this principle must apply to the question whether the claim falls within the spirit of the gateway. So it's one thing, it's one thing which it's not entirely clear what Collins was referring to. But then he continued, nor does it apply exclusively to the construction of the gateway. And he cited a dicta from the case of Mantle and Boschhoff, which the English Court here said that it would certainly contravene the spirit and also rethink the letter of the rule if jurisdiction is only assumed on the basis of some minor or technical or insignificant act or connection with the gateway or with the jurisdiction. So we'll come back to this later, because there's an important point in this passage from the Metal case, which is that in the Metal case, the English Court of Appeal actually thought that if a case has only a minor or insignificant connection with the forum, it would not only contravene the spirit, but it would also contravene the letter of the rule, which is quite a different version of the rule as expressed by Lord Collins. But in any event, Lord Collins cited this passage as a wider and more principled view in his opinion. And Lord Collins also thought that the Latin spirit rule is the answer to some situations where a claimant can create a link with England. He thought in such cases, rightly so, that the application ought to be dismissed. But then he thought that the reason or way of dismissing the application is by the use of the Latin spirit rule, which he thinks it provides the answer to this question. So he actually said that if plaintiff has no real connection with the forum, then the court may refuse leave or set it aside on basis that the claim is not within the spirit of the rule. And that is so regardless of whether the claim satisfied the forum convenience factors. That is also a point we'll come back to in a moment. So, going to our view in respect of the Latin spirit rule, the first point we make is that there is much confusion, in fact, as to the role that the rule actually plays, because if one reads Lord Collins' judgment in great detail, one will discover some internal inconsistencies within his lordship's reasoning. For example, one such tension is that his lordship has emphasized that the gateways are only a list of instances where there may be a sufficient link with the forum. So, put it in another way, there may not be such a link because, as Lord Collins suggested in his 4 examples, in some cases the link may be tenuous. Okay, so the link may not be substantial, but there may not be a real or significant link with the jurisdiction. And that is a matter recognized by Lord Collins himself. So, in our view, reading these passages together, a tenuous link with forum is not necessarily inconsistent with a claim being able to fall within one of the gateways. So that's the main point. That's the gist of 4 examples given by Lord Collins, actually. So that's one potential problem about the way in which Lord Collins expressed the rule here. But then there are also points in the judgment where Lord Collins appeared to say that in these tenuous cases, claim would not fall within the gateways at all. So, for example, in this passage at paragraph 117, Lord Collins said that in deciding whether a case falls within one of the heads of jurisdiction, the court must consider that blah, 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 the case must be clearly within both the letter and the spirit of the rule. That's the paragraph which I've read out. So, when we read this paragraph more carefully, one see this principle that a claim must fall within the letter and spirit of the rule is actually addressing the question of whether a case falls within one of the heads of the jurisdiction. So, in his lordship view, apparently, if a case does not fall within the spirit of a gateway, it would not fall within the gateway at all. But then that's great sort of inconsistency, because the very meaning of falling within the letter of gateway is that it prima facie satisfies what the gateway requires. Prima facie falls within the wordings phrase of the gateway, notwithstanding that we might dismiss such an application on another ground at a later stage of the analysis. But then at this paragraph, Lord Collins appeared to be saying that if the case does not fall within the spirit of the gateway. It will not fall within the gateway altogether. So that's another point of confusion arising from the judgment. So we actually see that there is confusion in various judicial remarks. For example, the passage in the metal case, which Lord Collins cited, which I just read out. So the Court of Appeal there said it would certainly contravene the spirit and also the letter. So that's the third way of conceptualizing the letter and spirit rule. Firstly, the way Lord Collins perceived it is that although a case may technically fall within the letter of the rule, the application will nevertheless be dismissed because the case does not fall within the spirit of the rule. Then in the metal case here, the Court of Appeal said that if the case doesn't fall within the spirit, also fall within the letter of the rule. So it's not merely falls out the spirit of the rule, but also doesn't fall within the letter of the rule altogether. So there are different ways and confusion about the role of the rule. Is it a test which should be conducted at a later stage of the analysis, or is it actually a part of the question whether a case falls within the rule technically? So if we look at Justice Zhang J.A.'s judgment in Dynasty Line again, we see that the second requirement of SOZAP is that discretion should be exercised in favor of the applicant, and then a serious issue to be tried at Hong Kong is the appropriate forum. So the point to note here is that the first requirement, requirement A, that good arguable case, is not related to discretion at all. But we only consider discretion at the second stage of the analysis, in which we consider the serious issue to be tried requirement, and also we consider the forum convenience question. But then with Lord Collins' analysis, the question actually, or the issues actually mix with one another. They're all mixed up in one big question of whether the case actually falls within the spirit of the gateway. So one can see this in different paragraphs of the judgment, for example, 114, in which Lord Collins thought that it is a flaw in the assumption that the discretionary element is limited to consideration of the forum convenience. This principle, by which it is the latent spirit principle, applies to the question whether one claim falls within the spirit of the gateway and not simply to the exercise of discretion. So actually, what Lord Collins meant appears to be that the latent spirit principle falls within A, the first requirement here, but then it is not merely a matter of discretion. It creates a sort of confusion in the role or the exact stage in which this principle or this analysis should be considered. So we also see from paragraph 118 that which Lord Collins said that if plaintiff has no real connection with the forum, the application may be refused, irrespective of the forum convenience analysis. So that is irrespective of the discretionary factors which the court considers. The point is that Lord Collins did not regard the latent spirit principle as a mere matter of discretion. In his lordship's view, the latent spirit rule actually occupies the fields to be considered at the very first stage of the analysis of whether a claim falls within a particular gateway. So again, we can locate various judicial remarks in which such confusion is apparent. For example, Lord Collins thought that if the case is not within gateway spirit, then it would not get through the gateway at all. So we've seen that already, even though it might be within its letters. So that's the basis on which Lord Collins may refuse an application, which is that although a case is technically within letters, but then the case is so tenuous, the connection is so weak that it's not fall within the gateway spirit. So we refuse the application, refuse leave to serve out. But then, in another case, which is the Sharap case, the English Court of Appeal actually said something in the entirely opposite way. The judge there said that I do not accept the submission that in order to get through a gateway, the claimant has to bring himself within the spirit as well as the letter of the rule. So here the English Court of Appeal actually did not agree or did not adopt the letter and spirit rule. And then the observations in some cases directed not to whether the claim should get through the gateway, but to the exercise of the court's discretion. So this back and value capital case is a case in which the letter and spirit rule was applied in England's case in 1975, in which the letter and spirit rule was used as reason or as justification of dismissing an application. And then in the Sharap case, the English Court of Appeal thought that the question of spirit was directed not to whether the claim gets through the gateway, but to the exercise of the court's discretion. So, in other words, even if the court accepts that there is such a letter in the spirit principle, the court here in the Sharap case thought that it only goes to discretion, but not to the question of whether the claim gets through the gateway, which is in sharp contrast with what Lord Collins has just said. That's really cool. His lordship thought that if a case so tenuous, so weak, it would not go through the gateway at all. So that's different conceptualizations of the rule by different judges. So basically, in this case, the judge did not accept such a rule. Then how did Lord Collins deal with this? He said that the Sharap case, contrary to the recent dictum by the English Court of Appeal, the Sharap case, in which the authorities do not seem to have been cited. So Lord Collins dealt with this apparently inconsistent case by way that in this paragraph, the relevant authorities had not been cited. But is it actually true? Because this paragraph actually referred to a paragraph in Dicey, Morris and Collins, in which the letter and spirit rule is discussed. And in that paragraph, it's quite clear if one takes a look at it, that the various cases in which the letter and spirit rule was considered or applied was actually discussed by Dicey, Morris and Collins. So one may not really say that in this Sharap case, the court was ignorant of the authorities or did not refer to the authorities. And there's also this metal case, which we already looked at, in which its conceptualization of the letter and spirit rule was that if one case is so weak, so tenuous, it not only contradicts the spirit, but also the letter. So that's the third way of conceptualizing the rule. So our view in gist is that it might not actually be necessary to revive the letter and spirit rule or the line authority which adopted that rule, because for the essential reason that its function has been well served by the doctrine of forum convenience. So spirit rule was often discussed in old cases as reason of dismissing a service hour application. But then at that time, in the early 20th century, for example, the doctrine of forum convenience had not become a well-established principle in English law. In fact, the principle of forum convenience has its modern form only after Lord Gough's restatement in case of the serious cases, including Spiliata, etc. So in the earlier days, there was no, the rule of forum convenience was not in the shape as it today is. So at that time, if you want to strike out, if you want to dismiss an application, an unmeritorious application, you have to rely on something, right? You do not have the forum convenience, you do not have the modern forum convenience rule. So the method adopted by judges at that time was to say that a case so weak, so tenuous, which does not have any connection with forum, does not fall within the spirit of the rule of the gateway. So that's the reason, that's the justification, but that's the way in which the older judges or older cases used to dismiss an meritorious application. But then, in the modern days, in 2024 now, we have the modern foreign convenience rule. And what we say is that we can rely on that rule to filter out case in which leave serve out should be refused. And it might not actually be necessary to revise old spirit rule in order to achieve that function. And to illustrate that point, we have looked at those cases cited by Lord Collins in support of the latent spirit rule. So one case was the case of Johnson and Taylor. So this case concerned a CIF contract for shipment of goods from a foreign port, Swedish port, to Manchester. So actually what happened was that the seller failed to ship the goods. So that failure to ship the goods was a breach. And that there is also another breach, which under shipping law, one has to tender shipping documents at destination of delivery. So there's also a breach in England where the seller failed to deliver the shipping documents to the buyer in England. So court held, despite the technical breach in England, which is failure to tender shipping document, the application for service out should be refused because the real and substantial breach, which was failure to ship the goods themselves, occurred outside jurisdiction. So the reason or the justification of the court in this case to refuse service out is that the case does not fall within the spirit of the relevant gateway. Then if one looks at the exact reasoning of judges laid out in imperative terms, new principle, court may do so, say the court has new power to dismiss an application for service out if the case does not fall within the spirit of the rule. But then if one analyzed the case in terms of foreign convenience, one could reach the same answer, which is that although there's a technical breach in England, the place or the jurisdiction with which the case has its most real and substantial connection is the foreign jurisdiction in which the real breach, the real failure to ship goods occurred. So applying this principle, one can see that the instant underlying breach, which is real breach at the foreign port, failure to ship goods, occurred outside England. And so for this reason, foreign convenience factors is not satisfied in the sense that England was not the it's not foreign convenience for the trial of action. And so leave serve out should be refused on the second stage of the analysis, which is the foreign convenience considerations. And so this case, if decided today, similar facts arise in England or Hong Kong, it might well decide on these grounds as opposed to the latent spirit principle. And that's the same for another case, which is the back and value capital case, in which there's a claim against various companies and directors in Bahamas. And the claim falls within one of the gateway, one of the necessary and proper party gateway, because one of the many defendants, or several of the many defendants, were some banks in London. So basically what the plaintiff tried to do is to use those defendants, those bank defendants in London, in England, as hope to serve out their writ to other defendants in Bahamas, lot of directors, companies in Bahamas. But then the court refused to leave on the grounds that the connection with London or with England is merely tenuous. The case for service out, the application for service out was premised only on the ground that some London banks were sued. And that's the only connection with England. And that's it. And all the other instances, all the parties, most parties, all other vendors were in Bahamas. And one additional factor was that it was almost impossible for the English courts to give a judgment in this scenario because it may not be enforced by the courts in Bahamas. So for these reasons, the court dismissed the application served out on the basis that the case was not within the spirit of the rules. But then again, if it's decided today, one may well say that the above factors are precisely from convenience factors, which the court may consider in an application for service out. And then the very reason why the court refused service out was based on these various from convenience factors, and that as a result, from convenience might be a better explanation, or at least it achieves the same result of the case if it's decided today. So the point again is that there may not be a great necessity to revive the Latin spirit rule here, because that's the Latin spirit rule was the reason or the way in which the old courts refuse an application. But now that we have the from convenience discretion, which is a structured discretion taking into account a range of factors, a range of well-defined factors like government law or the whereabouts of witnesses, evidence, or the location of the underlying incident, something like that, a lot of a range of principled factors, then it may not be really necessary to revive a rule which has caused much uncertainties. And one additional point is that in all these cases, there actually is no definition of what the spirit of the gateway actually is. So where do we look, where do we find the spirit of the gateway? In all these cases, the court, where the court apply the Latin spirit principle, they're actually weighing up from convenience factors as opposed to defining or elaborating on spirit of a particular gateway. So there is basically no definition of what the spirit is with respect of a particular gateway. So even if the rule has existed for over a century, there appear to be no detailed definition or no elaboration, actually, as to what is meant by spirit. And so, in our view, it's unlikely that the court will suddenly embark upon a detailed analysis on the spirit of a particular gateway, or particular rule in Order 11, in order to give a principled guideline to lower courts for further cases. But also, for the same reason, the cases on this point are invariably on their own facts. Courts are actually applying the usual from convenience grounds, and if so, a more honest, intellectually honest conclusion is that we are actually applying from convenience in the guise of a rule called Latin spirit rule. So why not we actually call it from convenience if we're actually applying those factors? So in our view, it is unnecessary to add further layer of complexity to this area of law, which is already very complex. So in a more recent piece by Professor Andrew Dickinson in the Cambridge Law Journal, he viewed the Latin spirit rule in quite a different way. His opinion is that there is actually something in the Latin spirit rule which is not reflected in the from convenience analysis or in any of the stages in the service out framework, which is that he says that if one accepts the Latin spirit rule, then one place to find or locate the spirit, the so-called spirit of the rule, is actually the underlying objectives in England or the overriding objectives in Hong Kong. The overriding objectives in England and the underlying objectives in Hong Kong. So that might be a starting point to locate the spirit of a particular gateway. So in other words, in construing a particular gateway, one would have to have in mind the underlying or overriding objectives after the CJR and Wolf reforms in England. And that's a plausible analysis of these rules. But then one problem about this analysis is that it actually means if we will be looking at the underlying objectives, it actually means that there may be cases in which all the elements of service out, all the requirements of service out has been satisfied. There's a good arguable case, a serious issue to be tried, and England or Hong Kong is the forum convenience. But then the application should still be dismissed because of the underlying objectives. For example, if it's disproportionate or if it's a waste of course. But then, in our view, it's quite difficult to envisage a case or circumstance in which this will occur, because those objectives or underlying objectives have in a certain way have already been factored into the forum convenience analysis. If an application is clearly unmeritorious, if the case clearly has no significant connection with the forum, then these sort of considerations will already be reflected in the forum convenience stage of the analysis. And it might be difficult to imagine a situation in which the underlying or overriding objectives may actually make a difference. So, before moving on to the recent Hong Kong developments, one further point to note is that our point is quite a simple one. It's that it is not necessary in these circumstances where we have the forum convenience rule now to revive the old letter and spirit principle. It is true, of course, that the letter and spirit principle has caused no harm. We're not saying that it would lead the court to the wrong conclusion. We're not saying that it did. But then the point is simply that it may not be necessary to rely on this old rule again for the purpose of dismissing an unmeritorious application, because that may well be served, that function may well be achieved by the forum convenience discretion, those factors themselves. So yes, that's basically our view on letter and spirit. So now hand back to Kelvin on the more recent analysis of recent developments of the rule in Hong Kong.
Thank you, Alex. So after the case of foreign authentic, there are only a few authorities, but all of them were delivered by the Court of Appeal, and therefore it is worth looking exactly what they say. So the first case that came after foreign authentic is the case of Holler AG, and that was a decision delivered by G. Lam J.A. And in that case, His Lordship held, after referring to Lord Collins's analysis, that at paragraph 33, apart from foreign convenience factors, this rule also applies to the question whether the case fall within both the letter of the rule and its true spirit, a requirement recently reiterated by Lord Collins in foreign authentic. So, but that is preceded by His Lordship recitation of the Order Rule 11, Rule 4.2, which states that no such leave shall be granted unless it shall be made sufficiently to appear to the court that the case is a proper one for service out of the jurisdiction under this order. As we have mentioned, this rule basically bonds out the requirement of foreign convenience. But it seems that what His Lordship was thinking was that this discretionary test includes indeed the letter and spirit rule. And it rather seems that the letter and spirit rule question would fall under the last stage of the analysis, which is the proper case or proper one for service out of the jurisdiction. Unfortunately, there was no subsequent explanation on this issue, for that was not the main issue before His Lordship. So that was this decision. And then the latest decision is the case of SFC and Isdell and Zabotic, delivered by Yun J.A. In that case, her ladyship again referred to Lord Collins's analysis, and over to the next slides, her ladyship said that Lord Collins held that the gateway should be construed in the natural and ordinary meaning. That is rather uncontroversial. He then recited, her ladyship then recited that he held that the jurisdictional test comprises a number of elements, compliance with a gateway being only one of the elements. That is also uncontroversial. But then moving on is that Order 11 Rule 1 does not reveal a legislative purpose that every gateway must be construed to require a real connection with Hong Kong, and then followed by some examples. And this is what we mentioned about the purpose of the jurisdictional gateways, which could also be tenuous. But most importantly, her ladyship then held that thus, when the court construes the gateways, it should impose an additional requirement of a real or substantial connection between the foreign defendant and Hong Kong. It will give permission to serve out of the jurisdiction if there is a good arguable case that a claim passes through a gateway within both letter and spirit. And at the end of the paragraph, it stated that it is the approach to be applied to all applications for service out of the jurisdiction. And from this paragraph, it seems that her ladyship considered the letter and spirit rule to be within the requirement of good arguable case, rather than the discretionary stage of foreign convenience, that is stage 3. So after Fong and Ascentic, these two subsequent authorities, both of which were delivered by the Court of Appeal, seem to be reaching a different points of analysis. One thinks that the letter and spirit rule should fall under stage 2, that is the good arguable case. And the latest authority by the CA thought that the letter and spirit rule should fall under the last stage of the analysis, and that is from convenience and discretionary test. So for the state of the authorities, we still have not had a definitive answer on where the letter and spirit rule should lie, at least in Hong Kong. And this issue has not been addressed by the UK courts. So, and this is the reason we say that the letter and spirit rule remains a point of controversy on the issue of service out. And at this instance, I think it would be useful for us to do a quick recap over the things that we've mentioned in this seminar. And it would be useful to refer again back to Lord Collins's analysis in the case of Fong and Ascentic. That is the second paragraph. So there are essentially 3 main points. So the first point is that the heads of jurisdiction does not need to be a necessary or substantial connection with foreign. And as Lord Collins said in his judgment, and he made clear that all that the jurisdictional gateways do is to provide a link between the claim and Hong Kong. There may be a sufficient link. It does not necessarily have to be a substantial or real connection. And that is followed by the 4 example we've just explored. The second point is the question of whether discretion is separate from jurisdiction. His Lordship again made it clear, and it is an uncontroversial issue, that the jurisdictional test actually includes the issue of discretion. The question of jurisdiction is ultimately reached by considering, as we have mentioned, first, a serious issue to be tried, second, a good arguable case, and thirdly, the issue of foreign convenience, and now maybe the spirit rule. It is by considering these factors that a court would ultimately come to a conclusion on whether the court has or will assume jurisdiction over a particular party. The third point, which is the controversial point, is that the exercise of discretion, as His Lordship consider, is not confined only to foreign convenience. He mentioned at various places in his judgment that the question of jurisdiction includes also the spirit rule. And from there, the 3 points actually arises, as we have explored in this seminar. The first is if the jurisdictional gateways are only a list of circumstances where there may be a sufficient link between the claim and the Hong Kong, then, but on the other hand, if the claim doesn't fall within the spirit, then it doesn't fall within the gateway. There may be a tension between these two analyses. And the second issue, which is actually more important, is where does the spirit rule actually stand? When, where, and where should we address the issue of spirit? Should it be under the good and arguable case requirement or the discretion requirement? And our view is that basically, as stated in our article, is that the issue of spirit rule should be subsumed under the discretionary test, discretionary stage. That is the last stage of the analysis. Because if the jurisdictional gateways or its letters are satisfied, then that's it. And one should move on to consider whether, as a matter of discretion, the case is also within the spirit of the rule. But unfortunately, in terms of the current state of the authorities, there isn't any definitive answer yet on this issue. So in terms of practice, although all these that we've stated may be a bit complex, but in terms of practice, I think what we think is that the spirit rule remains a live issue, especially it was given by the Court of Final Appeal. And therefore, in the future, in terms of making skeleton submissions or legal submissions to the court, it may become necessary to address this issue rather more expressly than before. But whether it should be placed under the second stage, i.e. the good arguable case, or the discretionary stage, that is the last stage test, whether in the skeleton submissions or the affirmation, that would be a grey area. And we will only have to wait for a more clear and definitive review either by the Court of Appeal or the Court of Final Appeal or some other decisions in the UK. And that, I think, would conclude our submission, our presentation on the issue of letter and spirit rule. And I shall hand over back to Professor Gibb for any questions.
Okay, thank you, Kelvin and Alex, for a very detailed presentation. And of course, at the end of the day, the problem is really that this has not really been clearly and finally resolved as far as Hong Kong is concerned. Now, if anybody has any questions, please put them on the chat function. One question that comes to mind is, why is a judge like Lord Collins emphasizing the spirit of the law, the spirit of the gateway? Now, to me, the most logical reason why a judge is wishing to do that is because they don't feel that the actual rules of the gateway are sufficiently clear to come to maybe a desirable conclusion about whether the gateway should apply or not. And therefore, what the judges are really doing in the spirit principle is really, in a way, trying to get around that unclear drafting, and therefore, if you like, putting a judicial gloss on the wording of the legislation. And the reason why I'm raising that is that some writers have said that one way to improve the law in this particular area would be to have better and clearer and more precise gateways. And if the gateways were better drafted, you wouldn't have any need for this thing called the spirit. So I just wanted to think what your view of that would be.
Yes, thank you for your very interesting question. That's certainly a way of conceptualizing the problem, because the way in which Order 11 was drafted was clearly not.
But sorry,
Alex,
Alex, could you improve your sound a little?
Sorry, can you hear me? Sorry.
Yeah, okay, thank you.
Okay, thank you for a very interesting question. What I was saying is that this is certainly a way of seeing the underlying reason of the problem in which all of these complexities are created, because the drafting of the rules itself not very precise. In terms of the rules, as I've just mentioned, we only have Order 11 Rule 4.2, which says that the no leave shall be granted unless it shall be sufficiently appear to the court that the case is a proper one. So at first sight, there seems to be a wholly unfettered discretion for the court without making clear what the requirements are. And it was on this basis that the court developed the two-stage analysis. But then I certainly agree that one way to make things clearer, leaving aside the individual gateways, is to at least generally frame in a more precise way the requirements in application for service out. And in fact, some of those requirements are actually apparent from Order 11 Rule 4.1. An application must be supported by affidavit stating the grounds on which the application is made, believe that plaintiff has a good cause of action, in which place defendants can be found, or the application, there's the real issue to be tried. One can see that some of the elements or some of the requirements are actually originated from here, although technically Rule 4.1 is a formal requirement stating what is required to be stated in the affidavit. But then we can see that a good cause of action, a real issue to be tried, these foreshadow some of the requirements as developed by the courts. So it might be a way forward to make things clear and make it quite clear that these are bases on which the court grants leave, at least generally, without commenting on any of the specific gateways. To make clear what stages or what considerations the court may or may not take into account or need not take into account in these applications. So yes, all those might be a sort of judicial response to a rule of High Court or a CPR rule which was drafted in such a liberal manner, manner.
Because to take just one very simple example, one of the gateways, of course, is simply if the contract is made in Hong Kong.
Yes.
And as we know, because of the crazy technical offer and acceptance rules, you could easily have a situation where a contract is made in Hong Kong, but of course, no connection really with Hong Kong at all. So you could argue there, surely, as a matter of common sense, this gateway should not apply, even though, literally the facts fall within it. And I do notice, we're trying to decide, what the meaning of the spirit is. In the case that you referred to, the Matau Rostov case, there is a passage in it when they're talking about the spirit, and the judge actually says, quote, "It requires the court to look at this gateway in a common sense way." Yeah.
Yes, yes.
So to me, that means the judges are saying, well, look, we need to interpret this legislation in a way that makes sense. And in that way, obviously, the so-called spirit can come in there to interpret it in a way that makes common sense.
Professor Gibb, so on this issue, I do certainly see the utility of clear drafting in terms of the procedural rules. But as you said, and even in the case of Maitov, the judge said that we have to look at it by way of common sense. But what does it mean by common sense? I think would inevitably depend on the circumstances of each case. And in that sense, it may not be absolutely, may not be 100%, may not be really useful in drafting the procedural rules in terms such that we can accommodate every situation. So I think almost certainly it will be useful to put it in clear terms what the judge or the court will need to consider under the procedural rules. But I think if the attitude of the court is such that we have to look at the case by way of common sense, then essentially one will need some flexibility while having certainty. I think clear drafting will certainly be a way to go. But at the same time, the issue, the concept of spirit coupled with the concept of common sense would inevitably leave some uncertainty in this area.
Yeah, because to my mind, the spirit seems to be really attempting to avoid forum shopping. And that surely is the job of forum non-convenience. So I think is that your point really, that the spirit doesn't really add anything to forum non-convenience?
I'm not sure what Alex thinks, but my thought is that the objective of the spirit rule may not be exactly the same as the forum convenience point, because for forum convenience, one, as stated in Spiliada, one is to identify a forum that is more suitably tried for the interest of justice and also the parties. But I'm not sure whether it is the same for the spirit rule, which requires the court to look at the substance of the matter, but not sure from which angle. And that's how I struggle to correlate these two concepts or reconcile these two concepts.
Yeah, I've had one question through, which actually was a question I was going to ask myself anyway, and I think I'm in quite good company in raising this question. Professor Briggs has been very forthright on this, and his view is there is no need for the gateways, that they don't really achieve anything, and that really whether a Hong Kong court should take on a case should be decided on the basis of forum non-convenience. That's his view. And, you know, historically, if you go back, you know, the first gateway rules were created in the 19th century when forum non-convenience didn't exist. So if when people were thinking about this, forum non-convenience had existed, would they then have thought we need gateways as well? So in other words, I'm coming back to the question, do you think the gateways really help and assist people? If we just simply have forum non-convenience to decide these issues, the law would be completely adequate. And of course, going back to the spirit again, when you look at the so-called spirit of some of the older cases, what is this spirit? It's forum non-convenience. Maybe not called under that name, but the spirit historically was very much forum non-convenience issues. So what do you think of the view that the gateways play no real use whatsoever They should all be abolished, and we just have forum nonconvenience.
I'll answer first before Alex puts forward his point. So
I know it's difficult for you because there's two of you, and you're not conjoined twins, so
yes,
you may have different views on the matter.
no problem. I'll just state my thoughts. So I think, as a matter of certainty, obviously there will be utility in having a set of procedural rules or so-called gateways through which a party making an application for service out could rely upon. But I think if we look at it from the angle of forum convenience, because as I said, the ultimate objective is to identify a forum which is more suitably, which is more suitable for the trial of the action, and that is in the interest of justice and the parties. And from that perspective, it may not be quite useful, or at least I do not see any particular use in having certain gateways, because ultimately one is to look at the case in the round, and just because you get through the gateway, it still doesn't answer the forum convenience question or even the broader question. So, for example, say let's say the limb on contract, you can satisfy the limb that the contract was made in Hong Kong, but still the court will look at the broader issue of forum convenience, and in that sense, we can say that there is little or no particular use in having the gateways.
How about you, Alex? Do you?
I'll just supplement two brief short points. First is that of certainty mentioned by Kelvin, which is a very practical and realistic point. Well, in my opinion, if there is no gateways at all, there might well be much more forum shopping than it now is, because people come to a particular jurisdiction and all contend that place right within jurisdiction, and all try the forum convenience test to try and serve out a claim outside the jurisdiction. If we have concrete and clear gateways, which is the thing remains to be improved, then the problem or the concern of forum shopping can at least be alleviated by these concrete rules, because if a claim or if a case does not have any real connection with jurisdiction, for example, with Hong Kong, then people will not issue a writ here to sue a foreign defendant, because they know that such an application will certainly be dismissed. And the second point is that the function of the forum convenience doctrine is merely to identify which place is proper place for the trial of the action. It serves quite different function from the gateway themselves, which are to confer power of the court to serve claim outside of jurisdiction. Of course, at the end of the day, we must remember that service out is not a matter of common law. At common law, the courts have no jurisdiction or service out of claim outside of jurisdiction. And so it must be a matter of statute. So at this juncture, what my view is that the way to improve on the matter is to have better or more clearly drafted gateways, as opposed to embracing a broad forum convenience principle and let that occupy the ground or all the ground. That's yes.
Yeah, I take your point that the gateway is looking at one point in time, and forum nonconvenience is looking later on at the stage of litigation. Yes. Oh my goodness, it's 2 o'clock now, so I'm afraid time is up. And I was going to give you a little problem question to solve for me, but I'm afraid time is up, so I can't give you that question. So thank you very much for your very interesting talk today, and a very complex area of the law. So thank you very much.